Good morning. My name is Tammy Smick. My husband and I flew here from Los Angeles to speak to you personally. The mission of the medical board is to protect healthcare consumers, but in the case against Dr. Daniel J. Hedrick, you have failed miserably. Your website states that death cases are given priority, but the complaint I filed against Dr. Hedrick took more than 4 years to reach a decision, and it took the medical board investigators 2 years after I filed my complaint to even interview Dr. Hedrick. My son, Alex Smick, went to Dr. Hedrick's facility to safely detox off of prescription pain medications. However, within 2 hours of arriving at Dr. Hedrick's facility, Alex was started on a lethal combination of medications. Dr. Hedrick wrote an order to check Alex's vitals only while awake. So the first night under Dr. Hedrick's care, Alex was left unmonitored for more than 7 hours without even one blood pressure check. When he was finally checked on during morning rounds, Alex was found dead. He was already in rigor mortis. My son had been seizing, vomiting, and fighting for his life after being given Dr. Hedrick's poisonous medications, but nobody came to help him because of Dr. Hedrick's orders. Nearly 3 years after I filed my complaint, an accusation was filed against Dr. Hedrick for repeated negligent acts resulting in Alex's death. Dr. Hedrick's license on the medical board's website even said, "Accusation filed, petition to revoke." I was relieved, thinking the medical board would revoke Dr. Hedrick's license and prevent him from killing another innocent patient. But in a confidential settlement hearing, a bargain was reached. I was told the stipulated settlement was confidential, and I would only be told the terms of the settlement once the medical board approved it. But I was certain that at minimum, Dr. Hedrick would be put on probation and have to take classes to learn about medications and monitoring so that other patients would be safe from his dangerous practice. But on December 21st, just a few days before this last Christmas, I received an email from the medical board saying a decision had been reached. I had to weed through a 16-page legal document to find the board's decision. I was shocked and outraged, literally brought to my knees. I felt as if a knife were piercing my heart when I read the words, "public reprimand." How can you allow a doctor accused of over-medicating a patient to death to get away with a slap on the wrist? Your job is to protect the public, not protect dangerous doctors. 42 years ago, the governor signed MICRA, the Cap on Pain and Suffering, into law with the promise that the medical board would be there to protect the public. But because of MICRA, you have an extra duty to protect us, and you are failing terribly. Shame on you. Shame on all of you.
We entrusted Dr. Hedrick with Alex's care, and his negligent acts killed our precious son. Excuse me. Do you have any idea what it's like to be taken to your son's hospital bed and to see his purple body with his arms above his head? Do you know what it feels like to feel your son's cold flesh? To try to move his arms down only to discover they are frozen from rigor mortis. That was Dr. Hedrick's actions. I cannot begin to tell you how appalled I am with the medical board's handling of our complaint. We trusted you to do the right thing, and you too have failed us. We went to the police and were told that the medical board would take care of it. We filed a lawsuit, but our access to justice was blocked by MICRA, the outdated cap on pain and suffering, and a CMA board member told us the medical board would handle it. So for more than 4 years, we waited for you to take action against Dr. Hedrick, and you did nothing more than give him a public reprimand. The Attorney General's accusation included sufficient allegations to revoke his license or at least rehabilitate him so he couldn't kill another patient. But you chose a confidential, secret deal. Pathetic. We are Where is the accountability? Where is the incentive to change? Hedrick is not deterred by any California law, and because of that, patients continue to be put at risk. His future patients will likely never know what he did. You had a chance to stop him, and you didn't. The next time Dr. Hedrick kills a patient, the blood is on your hands. Thank you.
Thank you. Ms. Webb, your presentation was very good. And I feel if the board were really following those disciplinary guidelines as you shared, I wouldn't be here. The first slide, protection of the public shall be paramount. In my case against Dr. Hedrick, my complaint against Dr. Hedrick, the public is not being protected. The purpose of disciplinary guidelines: act as a deterrence. Your public reprimand of Dr. Hedrick will not deter him from changing his dangerous practice. The slide on stipulations saying, a stipulation is a proposed settlement between the parties designed to avoid the delay. My case took over 4 years. Over 4 years. Talk about delay. I waited and waited for the board to take action, and still the action was unacceptable. On the slide, reviewing cases stipulations. Step 1, review the accusation, noting the allegations. Dr. Lewis, you signed off on this stipulation. I see he's gone. And I really would like Dr. Lewis to be here, because I want to know if Dr. Lewis even read the accusation. Did he even review the allegations? If he had, I don't know how he could have come to the conclusion that a public reprimand was appropriate in a death case. And I'm sure if his child had been given 11 medications within a 6-hour period and then had been left to die a slow, miserable death, only to be found in rigor mortis, I highly doubt that Dr. Lewis would have thought that a public reprimand was an appropriate discipline. Step 6 on that same slide, determine whether the stipulation provides sufficient consumer protection and, where possible, rehabilitation. In the case against Dr. Hedrick, there is no consumer protection and there is no rehabilitation. He can continue to practice as he has been practicing. He has not been, the board is not making him take classes to learn about the dangerous drug medications that he gave, about monitoring patients. So there is, again, no deterrence for him to change. And then the slide, the burning question. Under the facts of the case, the stipulation provides sufficient discipline and imposes rehabilitation in a timely manner. Again, no sufficient discipline, there was no rehabilitation, and 4 years is definitely not a timely manner. And that's why I'm here to confront you and to expose you, and I am going to fight to change this board so that consumer protection truly is paramount and not just a mission statement behind which you stand. Thank you.
Thank you. Any other comments from the audience? Yeah, Ms. Wright.
I've sat on this board since 2013, and I listen to the feedback that we get from members of the public. And I'm a public member. I know oftentimes the frustration is that there's doctors protecting other doctors. But if anyone's ever tuned into panel A and they've watched the line of questioning that I have, I'm usually very harsh, not only on our deputy attorney generals, but I'm very harsh on the doctor that kind of comes before us sometimes with almost an elitist attitude. Well, why should we even give you the license back? Besides the fact I'm a public member, I'm also a lawyer. And I can tell you that the reason these cases sometimes take so long, and I can even put it in my own experience, I have litigation that sat on my desk for 4 years because the other lawyer will go through all these legal loopholes and jumps and delays, ex partes, and constantly waiting to go to trial. I have a case that the lawyer has gone to ex parte to prevent the trial 10 times. Last time he came in with his arm wrapped up in a bandage saying he fell off a ladder. Whatever. I want to convey to you and anybody else who's listening that we take this very seriously. We're not sitting here, there's lots of other things we can be doing. Public protection is really important to us. Unfortunately, a lot of us, and we're frustrated too, we sit in a system that is a lot of red tape, a lot. So the complaints that you have are so much bigger than the medical board, so much bigger than the individuals that sit here. I am particularly empathetic to you and anybody else that comes here and presents about a child who has died, a mother who's been killed, an auntie. It does bother me sometimes when I leave these meetings, hearing you. Sometimes though, we are very limited in what we can say to you or anybody else, but please know that not only the doctor members, but the public members and our staff, you have no idea how hard we work to try to be fair. And in our panels, what do we do? So to know that when you come here and when you're seeking justice, that sometimes it's so much bigger than the 12 individuals that you see sitting here and the holdups. I gave you an example. Supposed to go to a trial in June. He came in with his hand wrapped up because he fell off a ladder. I had been waiting and waiting and waiting. So trust us when we say public protection matters to us. I don't know how to say it any other way.
Thank you, Ms. Wright. You summarized a lot of frustrations of the board members. Any other comments from the audience? Comments on the phone?
Marianne Hollingworth, your line is open.
Thank you. Good morning. My name is Marianne Hollingsworth, and